Welcome to the Drake Group's webinar series on critical issues in collegiate athletics. Today's discussion, Title IX and the NIL marketplace. Subterfuge or opportunity to remedy historical inequities. Our facilitator is Jama Meyer, Counsel Simpson, Thatcher, and Bartlett.
I'm going to facilitate, and I hope this is a pretty free-ranging conversation. As you all know, this arena whereby college athletes can receive monetization from third parties for their NILs is less than 5 months old. But it's a game changer in college athletes, but it's operating in a space with very little guidance from the NCAA, from OCR, from the federal government, from anyone. So we are going to try today give you some guidance that will assist you in understanding this new landscape. And new it is. I mean, who could have predicted the types of deals that we were going to see? We're seeing individual deals and team deals. We're seeing third parties involved that we never anticipated. Of course, we knew that the Wassermans and the well-established talent agencies of the world were going to jump in. But there are over 200 new entities that have jumped into this space to try to benefit from the new marketplace. So in that context, we're going to discuss where we think Title IX has its greatest implications. Recognize that sometimes the questions are maybe better than the answers. But let me framework our discussion today. We're going to first start with, what are NILs and what generally are Title IX requirements. And then I want to break up, although obviously there'll be some overlap, the discussion into what Title IX now requires with respect to schools in areas that directly implicate NILs for women. Secondly, areas in which schools are directly involved with NILs, such as approval of NILs, and how that impacts women and men. Thirdly, involvement of schools with third parties, for example, joint licensing, group licensing. How is Title IX implicated with respect to those? And then lastly, I want to talk about these third parties that have evolved and that are playing in this space. What are the school's implications or requirements or obligations with respect to those third parties if they're not abiding by the principles of Title IX, if they're engaged in sex discrimination. So with that roadmap, what I'd like to do is turn it back to Donna, again, who has incredible experience with Title IX, to just very, very briefly explain to us what Title IX requires. And then I'm going to flip to Julie to explain exactly what NILs are and what the current rules are with respect to them. Whoops. Well, let's do this.
No, I forgot I was on mute. That's okay. So, so the basics of Title IX in a quick and dirty. As you know, Title IX passed in 1972. It's a law requiring gender equity in the provision of all educational programs and activities that are recipients of federal funds. And while the law covers participation opportunities, financial aid, and treatment and benefits, including admissions and recruiting, today, we will mostly talk about treatment and benefits and how that pertains to NIL rights. I'd be remiss if I didn't point out that high school and college women are still being woefully shortchanged some 50 years after the passage of that law. How much? 90% of all colleges and universities are most likely out of compliance with regard to participation opportunities. Women are being shortchanged about $1 billion a year in athletic scholarships. And there's a $162 million gap in recruiting budgets, although dollar requirements are not applicable to recruiting budgets. And with regard to treatment and benefits, it's impossible to come up with an overall dollar value regarding the gender equity deficit. But anyone in the business knows it's significant in most of these areas. Just a few basics about Title IX assessment rules. You must only look at your institution's athletic program. You never compare yourself to other institutions in your conference or elsewhere. Second, you never compare dollar per dollar expenditures, except in the area of scholarships where the school needs to spend dollars proportional to male-female athletic participation with a 1% allowable variance. Third, you never count sports. You only count actual participation opportunities. 150 male athletes, 130 female athletes. And the basic equity standard is the percentage of male and female athletes in your program should reflect the percentages of male and female athletes in the undergraduate student body, with very limited exceptions. The treatment and benefits standard is important to understand because it has to be qualitatively equal. Not equal in dollars spent, but in the provision of equal quality in what those dollars buy. If football uniforms and pads cost $1,000 per player, you don't have to spend $1,000 on a cross-country uniform and dress them in chinchilla warm-ups. If you're allowed to treat male and female athletes differently, I'm sorry, it's not if, you are allowed, the institution is allowed to treat male and female athletes differently, but not unequally. And what that means is you can treat some athletes like kings and some athletes like paupers, but if you, and financially tiering a program, but if you do so, you have to have an equal percentage of female athletes in each treatment tier. So if you treat 100 football players and 15 men's basketball players like kings, and those 115 players, male players, represent 30% of all male athletes, you have to treat 30% of female athletes like queens. Two treatment and benefit areas are particularly important for NIL conversation, as I suggested before, recruiting, and then two things that kind of are intertwined, promotion and publicity. Two areas in which women have been significantly shortchanged. While you don't have to spend equal dollars on recruiting, if coaches of men's teams are financially supported to recruit nationally, going wherever they have to go to find quality athletes, bringing in as many prospects to campus as they want, then the same must be true for female recruits and for women's sports coaches. If you build a lavish lounge areas, give athletes sleeping pods or game rooms or lavish trophy display areas, if you provide that to a men's sport like football to attract impressionable 18-year-old male recruits, and then treat 100 male football athletes like royalty, assuming a 50-50 male-female split of athletic participation, equal quality facilities need to be provided to 100 female athletes. You get the idea. It really is proportionality going all through the treatment and benefits area. One more example, because it is important to the NIL conversation, is the Title IX obligation to treat male and female athletes equally with regard to publicity and promotion. Schedule cards, posters, billboards, radio and TV advertising, promoting athletes via television exposure. When the football team is on TV and athletes become household names because of this exposure, it affects their brand value, name recognition, numbers of social media followers, etc. If you shortchange women in this area, it will affect the female athletes' NIL value. Nobody cared very much before right now. Now, savvy female athletes are going to care what happens at the institutional level in terms of television exposure and recognition of them as athletes. So if the institution promotes male athletes via television contracts in the open marketplace, there is no obligation to find TV contracts of equal marketplace value for female athletes. But there's an obligation to provide equal exposure of female athletes and to make an equal effort to obtain fair market value and to obtain the same audience reach for those female athletes. And we'll talk more about that later. The last point generally is that schools cannot evade their Title IX obligations by asking or supporting outside entities to do for one sex what they are obligated to do for both sexes. If the school goes to Nike and gets an apparel contract for men's football, and I'm going to give you ORs, okay? And these ORs will apply throughout our NIL conversation. The school goes to Nike and gets an apparel contract for men's football. It's obligated to either get Nike to provide enough apparel to treat women equally, or to get another equal quality apparel company to give the same thing Nike gave, but to women, or to find other athletic department resources within the institution to buy apparel of equal quality so you can do the same thing. The school can take money from outside entities. It can take money even restricted for the use of one separate sex team, but it must always manage its obligation for balancing the gender equity scale.
Thank you. That was a terrific down and dirty summary of the settled law. Actually, just to follow up with your last example, maybe Gloria, could I ask you to explain the fundraising obligation, what the as it applies to Title IX? Donna touched upon that, but I think it'd be helpful to explain that a little fuller. And I know you've dealt with it before.
So typically in my experience on campus, each team would make a fundraising account, and the coaches would be responsible for raising the dollars that go into that account, and that would be money you could use above and beyond your general operations, special banquets, trips, foreign tours, whatnot. And depending on the program, sometimes the women's raise more than the men, but if the men raise more than the women, there's an obligation of the institution to be able to provide the same opportunity and resources on the women's side that the men's would be doing by taking advantage of this extra fundraise account. Don, I'm going to look to you to see if I got that.
No, yeah, absolutely, you got it right. And it's even allowed for the institution to accept a restricted gift from a donor. To say, a donor comes in and says, I just want to establish a football scholarship. Fine, as long as the institution then says, this scholarship thing has to be provided to women too. And that's generally the rule. The institution is the balancing act because Title IX applies to it.
So that's well settled law. And you can see that we can apply what you must do in those circumstances, whether it's fundraising or dealing with an apparel company, to the NIL situation. And we will get to that after we better understand what NILs are, what the landscape is. Why are we in this wild, wild west, especially with respect to the implications of Title IX and NILs? What are the NCAA rules right now?
Thank you, Jema. Delighted to be here today with Commissioner Navarez and Donna and Jema and all the expertise that you all bring here. Very quick history of NIL rights, as we all know, is name, image, and likeness, and how that evolved over the past couple of years. A lot has happened. A lot continues to be happening. So what are NILs? They are the rights for an individual to monetize their name, image, and likeness, to be used for endorsements, publicity, as well as self-employment. And it's a positive step for athletes. It's a step forward, treating college athletes like other students on campus. And it's a true game changer. It's been reported and estimated to be a $1 billion annually industry within the next 2 years. And the question, of course, we have today is, are women being treated and therefore benefiting equally? We are only 140 days into it today, into the NIL era. To give you an idea of some current figures, the company Open Doors, which is a company that provides technology for and manages NIL activity, they report that while a handful of high-profile athletes already earn over $1 million, including some of the top women, that the average monthly NIL compensation for Division I athletes is approximately $471. Those in Division II have earned an average of $81 per month. and those in Division III at $47 per month. And we are entering and in football season, squarely in football season now. 80% of the NIL dollars in the first month that it went into effect did indeed go towards college football players. Open Doors estimates that 50% of revenue is derived from social media. And we have licensing, team, group, co-licensing agreements, which we'll get into more today. And so those would be signing your rights away, allowing some to create apparel, trading cards, other types of merchandise using their NIL rights. It's another leading factor, and licensing is predicted to grow much more. We will explain later that on the money side, not a Title IX issue versus a marketplace. So it's important to make that distinction here, and we will. So the history of how we got here, to summarize everything that's happened, is that after some very significant court cases which had challenged the NCAA amateur as a model in college sports, preserved by NCAA bylaw 12 in the NCAA rule book over a couple of decades, there was a significant move in February of 2019 where California introduced what's called the Fair Pay to Play Act. And indeed, in September of 2019, California passed that law. And that gave California college athletes the ability to profit from their NIL and sign with agents. Immediately after that passing, in October of 2019, the NCAA Board of Governors directed its divisions to address NIL form. They had already, the Board of Governors, created what was called the Federal and State Legislation Working Group in the summer of 2019. And the purpose of that was investigating the possible responses to the legislation that had been proposed. So throughout 2020, the Federal and State Legislation Working Group presented proposed rule changes to the association. And by November of 2020, each division had drafted NIL legislative proposals. In the meantime, states all across the country followed suit, certainly after California, and throughout 2020 and 2021 in response to California, several other states had ended up introducing and passing laws. Brings us to January of this year, 2021, the NCAA, as they were working to present their own NIL rules, received a letter from the Antitrust Division of the Department of Justice cautioning them that their proposed model regarding concerns on any type of restrictions on an athlete's ability to profit off their NIL led to the NCAA indeed suspending their internal NIL reform. Fast forward to July 1st of this year, Florida, which had proposed and passed a law, an NIL law, along with a bevy of other states, they took the proverbial ball from California and made their effective date much earlier, July 1st of this year. Then we had the very significant Supreme Court case in Alston decided in this month prior to that, in June, which was not an NIL case, but the Supreme Court was clear in its ruling that the NCAA is subject to scrutiny when it comes to antitrust issues. By June 30th, the NCAA did adopt an interim NIL policy after the Division I Council agreed to support it. And that is to remain in place until any federal legislation or new NCAA rules are enacted. So we have 28 states that had enacted bills into law. 21 of them have been effective since October 1st. And it's important to note, as Jema noted, that the state's law do vary a great deal. Several states have unique clauses and nuances that limit NIL activity, even more than what's in the basic interim NCAA policy. And that NCAA interim policy basically is four bullet points, which in states, the first one is states that do have laws that are in effect. Individuals can engage in NIL activities consistent with the law of that state where the school is located, and colleges and universities may be a resource for the state law questions. The second, individuals can use a professional services provider, i.e. hire an agent. Third, college athletes who attend a school in a state without an NIL law can engage in NIL activity without violating NCAA rules related to NIL. And fourth, state law and schools, conferences may impose reporting requirements or other requirements related to NIL activity. What it does not allow, the NCAA, is for any NIL compensation contingent on enrollment at a particular institution, also referred to as inducements. So inducements are prohibited to enroll or retain an athlete at any particular school, and we'll discuss more about inducements and what are called impermissible benefits. It does not allow compensation for athletic participation or achievement, and it does not allow compensation for work not performed. So examples that we'll discuss today are group licensing, team-wide promotional agreements, and group and co-licensing. And there are questions surrounding some of these agreements as to whether they're based on the value of an individual NIL, or rather the team members collectively, which would run afoul of state law and NCAA policy, as those individuals playing for that institution look and seems like a pay scenario, which is prohibited. So
Julie, would you agree though that we've got these few rules, and basically it is no pay for play and no NILs cannot be used as inducements, but there are no standards right now with respect to Title IX and how NILs are implicated by Title IX. Right?
Correct.
Okay,
Exactly.
so given that's true, let's back up and Donna, can you focus us once again on the areas where Title IX applies, yet schools are not actually complying with Title IX? How is that lack of compliance undermining women's NIL efforts and deals?
Well, we don't know what's going on at the campus level, but there are 6 areas that everybody should be focused on with regard to Title IX and NIL specific obligations. First, lots of talk and requirements dictated by some state laws that the institution provide NIL specific education programs, financial literacy, brand building, entrepreneurship, contracts, taxes, and if those programs are provided, they must be provided equally to male and female athletes, says Title IX. The second area is the disclosure and approval of athlete NIL deals. So the institution has an obligation to hold approval of men's and women's agreements to the same standards. There can't be a wink and a nod. Oh yeah, go ahead for guys, and the women be held to a different and higher standard. If there's disapproval of an agreement and the institution provides help constructing an agreement for men, it has to do the same thing, it has to provide help constructing the agreement for women. The third area would be informing athletes of regulatory functions, the requirements of state law, the requirements of NCAA rules, because the institution has an equal obligation to protect the eligibility of its male and female athletes with regard to NCAA rules. And for sure, it doesn't want its athletes to get on the wrong side of state laws. The fourth area is, as I've said before, promotion and publicity efforts of the school are going to come under new scrutiny, just as the NCAA television contract did during this past year's Final Four. As female athletes learn about the NIL value of their personal brands, they're going to really, with a magnifying glass, look at what the institution is providing to male and female athletes respectively, just like Sedania Prince did, trading video messages with her male teammates at the Final Four. Another area is recruiting. What we're seeing that I don't think we anticipated was coaches of male athlete recruits and ADs, athletic directors, bragging on NIL deals, bragging to alums or to high school, conventions of high school coaches, encouraging, telling them, hey, our guys already got $1 million in NIL deals. And when they talk to alums and their supporters, encouraging them to make sure that the institution wins the new NIL arms race. And so the caution for Title IX is the messaging. If that's the messaging that's out there, it needs to include the importance of an equal NIL effort for female athletes, because that's the institution's obligation of equal treatment. So its messaging should match. And last, to the extent, and Julie mentioned this, to the extent that the institution engages in licensing in conjunction with its athletes, if it allows athletes to use the marks of the institution, it must treat them equally with regard to soliciting and accepting such deals and allowing males and female athletes both equally to use their marks.
That's very helpful. I wonder, Gloria, what are you seeing in terms of schools' involvement, whether it be in the context of approval of deals, of educating athletes that might raise some Title IX concerns, or where schools should particularly be concerned about providing the same for men and women?
Yeah, and as Julie and Donna referenced, it is the wild, wild west out there, largely because we don't have a lot of guidelines on the books. I mean, at the very highest level, we must allow student athletes to monetize their name, image, likeness. And on the other hand, schools are not allowed to use name, image, likeness as pay for play. And that right there is a huge broad category. And schools are trying to navigate, where are we in this? Because we have a responsibility to report. But as Donna just said, and as Julie mentioned, if 70, 80% of the deals out there are happening around football, where does that leave the school in trying to equitably be involved in right-sizing these opportunities for the women in their programs? Because you can't use them as inducements. So as a school, I think they're trying to figure out what is involved. There's a role for enforcement and an education, but there's also a role if companies are coming to you, you're saying, no, you can't do that. No, you can't do that. No, you can't do that. And the company says, well, what can I do? Where's the school's line? Can they say, well, you can do this, this, and this, and then can you publicize it and promote it after the fact, or does that then become subject to Title IX? So I think Donna did a great job of outlining those areas. What I'm seeing from our schools is either a lot of caution or a lot of documenting as they go through this process, trying to figure, when they make decisions, keeping track of the who, what, where, when, why, because a lot of times the headlines can say one thing, but the reality behind how a school came to a decision can be another.
And just how deeply involved can the school become? Let's say there's a deal up for approval. The athletes brought that deal to the school to either disclose it, or in some states you're required to actually get prior approval, or some schools require that. What are you seeing in terms of schools' involvement in that construction? Is approval of the deal, and is that a perfect time at which the school then can get involved in making certain there's equitable treatment for men and women? And how do they do it?
From my perspective, all of our schools are doing the, education, really trying to teach student athletes what this NIL means, how to retain your eligibility, and the monitoring. That's a huge chunk, and I think everyone's in that space. The question you hit on, Jema, is, okay, now we have a big deal coming in, and either the athlete's asking for the institution, how do I structure this? What can I do? Athletes are permitted to get third-party professional advice and agency, but where can that school be? And I think that is the wild, wild west. We've seen schools all the way down the road with helping to outline what can and can be done in the deals that are eventually signed by the student athletes, to other schools that are hands off, like, sorry, you're on your own. You gotta find your own agency, and you're the ones who have to talk. So I hesitate to say what schools should or should not be doing, because right now there's a whole spectrum. But I think where we have counseled our schools is, if you're calling the NCAA getting advice, track that down. If you're getting advice from your own counsel, make sure that's all kept record of, because at some point, ideally, we will be putting guidelines and guardrails around this. And you want to make sure that whatever you did during this interim time, you can justify or defend, because there don't seem to be a lot of clear cases of right and wrong.
Gloria,
you-
I have a question for Gloria. Gloria, is the NCAA doing anything in terms of issuing any guidance? Have you heard anything out of the NCAA office?
What I've heard, and this is anecdotally, is when they're involved, they're only being involved in the biggest cases. So working with schools, and I think the Oklahoma Lululemon example was one that I had heard the NCAA actually got involved and provided direction on what would not be compliant with NIL. But for the most part, I haven't felt or seen in our footprint them, the NCAA proactively, much like they would with other pieces of legislation, get really proactive and either say, hey, school, we heard you might be doing this, that's not right, or proactively answering a ton of questions from the membership about what they can or cannot do.
But are you aware of schools explicitly calling the NCAA and seeking advice?
Not in my footprint, but I have heard that that is being done, and some are getting, totally anecdotally, some are getting, sorry, can't help you. And then if it is really kind of this big, clear case scenario, being told yes or no.
Okay, and that's not being compiled anywhere, I take it. It's not being
No.
shared, that information, so other schools or conferences might know about it. Let me ask you, I believe there was an example in a school in your conference that involved a full team, maybe the football players, you know, because we face the football season first here, many of the deals obviously are being given to football players, either individually or as whole teams. Are you aware, I think we had talked at one point about an example where a full team did enter into NIL deals and came to the school and talked to the school then about gender equity issues relating to that?
So, and the deal you're referencing is the Brigham Young, BYU built deal, and built a current sponsor of BYU athletics wanted to do something for the football team and said, hey, BYU, can we do this? And BYU responded, no, that would violate NIL and eligibility. And they kept serving up examples. And the way I understand it, BYU said, okay, if you want to do this, help football players, this is how you do it. And they landed on giving or providing NIL deals for all the walk-on players on the football team. And when Built inquired, what would be a useful amount, it ended up being the cost of books and tuition. So Built then went away and made individual contracts with all these walk-on student athletes. And I think the BYU case is a good example. There are a lot of folks out there that says, well, that's a clear case of the school being involved and helping broker the deal. If you ask BYU, they say, no, we didn't bring them to the table. We guided them in the proper way to preserve the student athlete eligibility and then publicize the deal, but we did not go actively solicit this in the marketplace and bring it in specifically for football players. Again, within this world of unknown, BYU also had an opportunity to provide the same for women through a different company. It's not this exact same deal because in the women's sports, you have a lot of equivalencies and they were working that out. But it's a classic example of a school not wanting to say no to everything just to be on the safe side, but also trying to navigate this environment that doesn't have a lot of guardrails and protect their student athletes.
So if a school wants to be certain to avoid any Title IX problems, in a situation like that, where the school is more than even just aware of a full team deal for the men, what should the school do?
So, just a side note before answering that question,
Yes.
What I found very interesting and what I'm seeing, while there are some individual deals, many of the deals out there are still about the brand across the chest. This is a good example of, this was a company that wanted to be associated with BYU. The names of those walk-on student athletes were a little bit inconsequential with regard to driving brand value here, right? And a lot of, I heard of one at, University of Texas and the burnt ends, the same thing. It's still about the IP value behind the school's brand. So we're gonna have to find a way through to allow the school to be involved to some degree to protect their own marks, to protect their student athletes, and really to make sure the IP is using in the right way, especially when it's a collective, not an individual. It's one position on a team for the school.
A question for Julie. Are there state laws that exist right now that prohibit the institution from giving its brand to, to its athletes, giving its marks?
Yes, there are states that have that type of clause. I couldn't give you which ones off the top of my head.
That's
I
right.
think Florida prohibits it,
Yeah.
I believe.
The cleanest, I'm curious what you guys think. The cleanest way to really stay out of trouble would be like the pros. If the pros are doing advertising, they on their own, they can't use their team uniform. They can be in the colors, they can be in football outfits, they can do all those, but they don't trespass in terms of the use of team marks. And in terms of keeping that line between the institution, hey, I'm not a business partner of my student. I'm not the employer of my student. I'm not giving my student pay for play or anything of value like my marks, right? The cleanest way to do it would be to prohibit that intersection. You keep people out of trouble. But what do you think of that?
I feel anecdotally, I've heard, well, I know at least in our league, all of our schools have prohibited the use of the student athletes using the marks unless it's associated with promoting the school or their own personal brand. But if they're going to monetize, say, giving a pitching lesson on the side, you can't use the institutional marks. And if you're going to use the institutional facilities, you have to pay the going public rate in order to.
So it has to be a co-licensing deal or a group licensing deal or some place where the institution benefits, or it can just be publicity for the institution.
It could be publicity, but it starts from a place of you don't automatically get to use the marks.
Yeah.
And that's clean. But I think, back to what is impermissible? It's impermissible to pay for play. So it's impermissible in the cleanest sense to say, you come to my school and you'll earn $50,000 in name, image, likeness deals, pay for play. But being at a school that has a great brand value that, hey, just by playing at this school, you're going to probably open yourself up to a ton of NIL deals. That's where you start to get gray, right? Because we have schools that, hey, if you want to go to school on the beach, come to our school. Is that pay for play? Is that a recruiting inducement? No, that's a really nice perk of being at that school, in that location, in that market, and in that brand. So I think what we need more clearance. We need more clarification, I should say, on where you actually traipse into pay for play, because we're already at an unequal playing field, and schools got a ton of either benefits or perks or things unique to schools that are recruiting inducements. They make it for both athletes and non-athletes, makes it a great place to go to school. And we all know that this area is ripe for abuse. And that's, I think, where we're trying to draw the line. We don't want to abuse, into pay for play, but we're at a competitive recruiting market where you absolutely want to be able to say, we're better than the other school because of X, Y, and Z.
And I think that's why a lot of schools too are entering into these group licensing deals, among other things. But let's touch upon group licensing. I know Donna brought it up. Julie, what exactly is a group license?
So we have, we mentioned, I believe, co-licensing and group licensing. And quickly, so a group licensing, I'll start with co-licensing, gives, where the school gives an athlete permission to use the school logo or say the view of the school's facilities. And the athlete is compensated for the use of their own NIL, which includes the university marker logo or the view of the facilities. So the athlete essentially creates their own brand and logo, but incorporates the university marks or logo. On a group licensing arrangement, it's not as direct. It's more of a triangle arrangement where the third party deals directly with the athlete, theoretically with the school separately. So the third party pays each separately, but the deal is dependent on both the school and the athlete entering the deal with the third party. The question, of course, we'll discuss more is this sufficient to trigger a Title IX obligation for the school? I think probably the best, one of the best examples of a group licensing agreement are the video game scenario. That triangle arrangement could also be trading cards, jerseys with the school and the athlete name for sale. And again, with a video game arrangement, you look to the money flow. For example, EA Sports pays the school for their use of the facilities or logo, and then separately EA would pay the athlete as well.
Well, Donna, what are the Title IX implications of those joint licensing deals?
We don't have any rulings, but it's almost like a reasonable person analysis in that in the three-way deal, the institution knowingly enters into an agreement to benefit athletes of one sex. Video game company comes in and says, I'm doing NCAA football video. And the institution is not lending its mark to anybody but its athletes, right? So it knows I am entering into an agreement, almost like a television contract, right? That just benefits the football team. Now, so what is its obligation? I think the three-way balance or comes in. You ask the video manufacturer, the middleman, can you do both? Can you include women? Or secondly, can you seek a similar deal for female athletes? Maybe there's a women's basketball video game or an equal number of athletes video games. Or you might internally design some kind of a balancing solution that uses institutional resources. And I'd have to think about that for a second, but and maybe you can talk about this, Gloria, because you have to look at it from an AD standpoint. If I believe those deals aren't out there because my kids, my underrepresented group is insufficiently exposed, then maybe I can put more money into promoting the underrepresented sex and making their visibility higher. I'm in that place where it's so new that I haven't even thought of all the things the institution could and should do. But Gloria, you've been down there. So
and again, as you said, we've done some thinking on this, but I don't know I've landed on any answers. But do you distinguish between, okay, I have an all-star quarterback that went out and got a ton of deals based on that individual's capacity as an all-star quarterback? Do I need to right size that on the women's side if I don't have that same singular athlete with a singular brand versus I've got a collective, or I've got a team-wide deal on the men's side that I then may have an obligation to right size or provide equity on the women's side? And where does that stop? Is it, they have one position group on the men's side on a football team? What does that mean on the women's side? All the defensive backs in my soccer team or something. And I think that's where it's really, really hard, because what is market value? There's the market value between that individual who's kind of just come in and a rock star versus the value that's provided by competing with the letters on the chest. And my gut feels that when it comes to the value of the letters on the chest, that's probably where you might have more of an institutional responsibility to right size or
I agree.
provide equity.
I agree. I think that's a great line in the sand, because it's so clear that what the individual is doing is reflecting that individual's marketplace value. They're already coming to the game with 20,000 followers on their social media, or agents just begging for them. So I like that line.
So we clearly need some more guidance in this area. What's interesting is that the NCAA during it was probably almost 2 years when they were developing guardrails, suggested guardrails that the NCAA never ended up voting on, actually suggested that group licensing be prohibited, to wait and see how things develop before appropriate rules were put in place. So it's happening, and we don't have those rules. Let's jump. We're starting to get a little tight on time, and I want to jump to an area that I think is even fuzzier and needs even more guidance. There just isn't any sufficient analogy, although we've got one. What happens when third parties are out there performing or performing some of the activities that the university otherwise might? Especially, I'm thinking about recruiting, I'm thinking about collectives, initiatives. Tell us what's happening there and what are, what should be done? What are the Title IX implications of what's going on? Gloria, you want to take a stab at it?
Well, Don, you want to start with collectives and then I can go into.
Okay, great.
So collectives, right, are out there, and this is the booster club who, at the behest of the coach who says we have to win the NIL wars, they go out, they start another booster club, but they call it the NIL Collective or the Gator Collective and a whole bunch of other names, right? But it's the same boosters that, if they gave anything to the institution would have to split it equally. Now these boosters are acting as third parties who are advancing only the interest of athletes at one institution, and everybody knows it. And so it's advancing the recruiting interest of the institution. Recruiting is absolutely a Title IX obligation, equal recruiting. And I think what happens with the collective is exactly that three-way street, that the institution has an obligation to, educate them first and foremost. Come on, you guys, if you're identifying opportunities for our athletes, it better be for both men and women. We have to comply with Title IX, unless you want me to sever a relationship with you. Unless maybe you don't want to be eligible for prime seating and season tickets, or think about how the NCAA would sever an agreement with a representative of athletics interests if it broke a rule, right? So I think education is the first step. It could look for another entity that would just help its underrepresented sex, or as I suggested before, that if it struck out and it had to, shut down the relationship with the collective, that it might think of another way internally to balance the act. But it is this one is just a mess. I think what we're going to see in a very short period of time is some of the minor revenue sports starting their own sport-specific collectives to help minor sport athletes. You're going to see the big collectives do what they always have done: football, basketball, right? And then not willing to be left behind. I think we're going to probably see these other things pop up too.
Yeah, I think, well said, Donna, because that's the area that really, again, that line, what is paying for play? What is paying for coming to the school? You can have a booster out there who says, I want to build a palatial gym. And guess what, recruits? If you come to this school, you get to play in this palatial gym. That's okay. Now you got boosters saying, hey, I want all the athletes on this basketball team to tweet for me, and you get, I don't know, $10,000 each. That's okay, but how do you tie that back to the institution and make sure the women get the same exposure, same opportunity? And what's the obligation on the institution to right size that, I guess? Can't think of a better word. And again, the way I just articulated it feels fine. If you come here, this is part of being with this big program and all these benefits, versus actually saying, I'm paying you to come here, play here. This is an arbitrary distinction.
Yeah, what makes me think that the institution should be exercising its muscle with these collectives is few people realize that the NCAA under NCAA rules is responsible for any entity that is acting on its behalf, be it a representative of athletic interest, a corporate entity, an organizational entity. That is smack dab in the NCAA rulebook. It's not a Title IX requirement, but the institution is used to this, that it has an obligation if it knows somebody is doing something that it's going to influence its ability equitably deal with men and women, that the institution bang on that drum.
Oh, and during this wild, wild west, both the institution and athlete want to ensure the athlete, A, doesn't get harmed, doesn't sign their rights away into perpetuity, or, you know, go into some agreement that's not good for the athlete and jeopardizes their eligibility. So there is the carrot for the institution to protect the athlete, stay involved, but I don't know that yet we have the direction for the school to lean on the consortium or exercise their muscle. To what degree? What exactly are they trying to prevent? And that's the great unknown. And I feel for our schools right now, because I do feel a lot of them are trying to do it the right way and do the right thing in this great unknown.
But what we do agree on, I think, is that the effort that the collective has to make has nothing to do with the value of the NIL in the marketplace, right? That the marketplace determines what the value, what you're going to pay for every NIL. But the collective who is hustling the money, hustling the deal, should equally hustle for male and female athletes, no matter what their marketplace value. That's the obligation, not to match marketplace value. Yeah.
And I thought you made a great example in media rights. As if we're hustling for both, to put both on linear, but say we got more money for linear on one gender, but we provided a digital streaming package on the other, we're working hard on both, but we're providing for both. And that, I think, is the analogy that you gave that extends through NIL.
In terms of the university's obligation in dealing with these third parties, Julie, is there an analogy from any letters or guidance from the OCR with respect that we could maybe apply in this situation with respect to NILs?
There is indeed fairly recent authority that could lend some guidance to the NIL landscape. Situation concerns school involvement and assistance with third parties other than via co or group licensing deals, and other than groups acting as surrogates for schools' activities in like recruiting. The Office for Civil Rights, also known as the OCR, which is part of the Department of Education, they're responsible for the enforcement of Title IX, and they responded to a 2017 endeavor to form an HBCU men's only basketball league and paying the students to play and allowing use of the school's gyms and school marks. And that did shed some light on schools' Title IX's obligations in dealing with or assisting or aiding third parties that discriminate on the basis of sex. The OCR said that the institution may be in violation of Title IX when it assists an outside organization that engages in sex discrimination. And it emphasized that as part of its broad prohibition on sex discrimination, and that Title IX regulations prohibit recipients from aiding or perpetuating discrimination that discriminate for providing aid, benefit, or service to students or employees. Similarly, a recipient that assists an outside organization in making employment available to any of its students must assure itself that employment is made available without discrimination on the basis of sex, and not render such services to any agency, organization, or person which discriminates on the basis of sex in its practices. So the OCR said that schools must not assist, aid, benefit, or render its services to a third party that discriminates on the basis of sex, essentially saying that you cannot engage in non-NIL sex discrimination. So it could illuminate how the government and courts may view an NIL arrangement with a similar goal or influence. If one indirectly violates Title IX or it's the spirit of the law, or whether through knowing inaction, encouragement, or other active inequitable involvement that will negatively impact women's NIL opportunities, then the school could have Title IX liability.
So that's helpful. We'll see. We definitely need the OCR to weigh in on a situation that directly involves NILs. I'd like to jump to conferences and the NCAA and what their Title IX obligations might be in this area. How might that come up with respect to NILs, and what is their obligation?
So right now, again, Wild Wild West, the conferences can choose whether to be involved in NIL regulation at all. There was some language, and I believe it was Alston, that provided the conferences the ability to set some limits without subjecting to antitrust, because conferences don't represent the whole national market. I haven't really seen a trend yet for conferences to get in and be either a clearinghouse or a broker of group deals or league-wide NIL deals. Most conferences have chosen to let the schools deal with that individually. However, some conferences have launched some robust education and, training type, what to be careful of, how to think of your brand, that type of thing. But a vast majority are leading this to the campuses individually.
Okay, and I guess if the conference permits athletes to use their logos or marks, we come up with a similar situation and obligation as we would with schools. Have you seen any of that?
Well, absolutely. And that's kind of a long time conference, position. While we have our own brand and marks, most of the affinity is really about the institutions. We're the umbrella. People don't graduate from the WCC. People don't, come to see games because they're WCC, except for our championships, which again, the culmination of the individual brand rights. So we wouldn't want to do anything, at least in our league, that would cannibalize individual schools' ability to monetize their brands. So we, as the WCC, have not yet been in this space. Could there be a future? Absolutely, especially around our championship events and those participants in that event. But again, for me personally in the WCC, we're waiting to kind of see how the market plays out, and we're hopeful that the institutions are maximizing their ability to promote their own brands and student athletes under this.
And I guess sticking with the conferences in NCAA for one more minute, right now there is no precedent holding conferences and the NCAA to Title IX obligations. No legal precedent. We do have precedent in the high school area where high school athletic associations have been held responsible under a controlling authority theory. So it'll be interesting to watch over the next few years. I know there are people out there and organizations who are looking to challenge that. So that will bring a whole nother host of questions to the NIL landscape. If they're formally, legally held to be responsible under Title IX.
Right, and in the past, that's because the NCAA nor the conference office are recipients of federal funds. We're pass-through of most dollars that are earned through the CBS contract in the NCAA basketball tournament. But to your point, 2 days ago, was it 2 days ago? Wow. The NCAA Special Convention, and I serve on the NCAA Constitution Committee, unveiled a draft of the new Constitution. And in that, it reads, "It is the responsibility of each division, conference, and member institution to comply with federal and state laws regarding gender equity." And of course, there will probably be a lot of, detail coming in phase 2 and as we live under the new Constitution. But the original intent was to say, look, our conferences, all of our schools are subject to Title IX because they receive federal funds. The conferences are a direct reflection, or the house that under which these schools live, they should comply with those as well. And the NCAA, especially after, the examination of the men's and women's basketball tournament that Sedona Price brought to light last year, that both the conference and the NCAA should comply to the same level that the schools are doing. Now, we're not built the same. We don't have all the laundry list and locker rooms and everything else, but really brass tacks when it comes down to offering championships and exposure, that's the lane we live in. We should operate the same way as campuses.
Right, I couldn't agree more. Let's turn to Q's and A's. I'd like to go ahead and start with the first one, and then maybe some of my co-panelists here can look at the other Q's and A's to see what would be particularly relevant to ask. So the first question is, if when we get to a federal solution, it's really when and if we do, what guardrails would you see as necessary, especially as it relates to protecting / enhancing gender equity or at the very least, not exasperating current inequities? I think it's a great question. Who would like to tackle that one?
Well, I'll throw in 2 cents. The original thought in terms of federal legislation anticipated an NIL commission taking responsibility for aggregating all these NIL deals. So it would act with knowledge 3 or 4 or 5 years down the road to be able to identify the guardrails that they needed to control this space. Now what you see is, absent federal legislation, institutions have that burden of only keeping track of their own deals. There is no national, there is an effort on the part of some people to keep some kind of a media-based national database, but we left the institutions out in the cold in terms of dealing with any of this. I think the other concept that was important was fair market value. How do you know whether there is an inducement or extra benefit if there's no data upon which you can analyze fair market value of a deal? All of that analysis depends on that kind of knowing what the market rate is, say nationally, for a specific requirement for an athlete to do something if the athlete has a certain background, right? And we do have comparative data in terms of professional sport athlete data, you know, that we could at least rely on an interim basis. But everybody should be concerned, because you can't operate an interstate program like intercollegiate athletics with 50 different state laws. It's like crazy, right? And what disturbs me is that the NCAA is playing chicken. I'm not going to say anything. I'll just make the chaos worse by not stepping in and trying to help. And I think that's unfortunate.
And I would just add, I do think, I believe there has to be a way to let the institutions be involved in this space in order to help guide and protect eligibility and advise student athletes and make sure these things are being done the right way. We all know we have not got the right answer in the NCAA with regard to enforcement, and we're all worried about the abuses of this area. But that, to me, follows with the entire handbook and all the recruiting violations we've not yet been able to get our arms around. So I do feel that in addition to some NIL guidance, we've got a big issue with regard to enforcement in our association that really needs to be addressed. And I know good people have been serving on committees and working on it. And we do need some federal help in giving ourselves clearance to make some of these regulations without being subject to antitrust or, lawsuits and such. But I think we can't talk about one without talking about the other, because that's the fear with the NIL, is the lack of enforcement.
Yeah, and everybody should know that our very next webinar on December 2nd is going to talk about that Congress is the only ones that really can help a national governance organization of this magnitude with regard to the power it needs to enforce, namely maybe subpoena power, maybe giving that to federal judges within that, within the context of an enforcement system. And then the other piece of the puzzle is a very strict conditional antitrust exemption that doesn't give the NCAA protection from athlete lawsuits, but says this organization has to operate in this way, like giving due process to athletes or giving due process to institutions as a condition of taking the advantage of that exemption. So it's very complicated, like NIL, but we'll try to tackle that in our next webinar.
Thank you. I mean, just following up briefly, Gloria, on what you said. I have to tell you, I sleep better at night knowing that you're one of those good people trying to figure all of this out.
Here,
We're
here.
very grateful to you for all you're doing on this. Let me go to another question, and maybe we can expand this a little bit. The question relates to California state law to start with, but I would expand it to any state law. So really, are there state laws that have any language requiring compliance with civil rights laws in regard to structure of NIL market in institutions? Can OCR develop guidance or even regulations that will enforce Title IX across a variety of state laws and institutional differences? This is a run-on question. And do we need to seek state by state provisions in their NIL laws to beef this up if there isn't any? So that's a mouthful, sort of very, very good questions. I guess it goes to solutions again, right? What do we need to do? And maybe, we haven't talked about the UCC effort. Maybe Julie, do you want to talk about that as maybe a possible solution in this area where we're dealing with states and different laws?
It's an excellent proposal. It deals strictly with NIL rules, not so much any more comprehensive Bill of Rights for college athletes. I think the obvious obstacle with the ULC effort is that every state must choose to adopt that effort. So much like the Uniform Athlete Agent Act, which I believe is adopted by 47 or 48 states, each state session would need to be in session and then choose to adopt the ULC effort, which was introduced this past July. So with regards to the first part of that question, in California, don't believe there's really a reference to civil rights. They reference a student athlete rights as existing California, a separate existing California law. But what they proposed in Senate Bill 206, their fair to pay to play, was really dealing with NIL rights. And I would say the OCR could develop guidance.
Absolutely. The OCR, as a federal, part of the federal government, develops national guidance. So that would probably overrule or would take care of the hodgepodge of state law provisions, or could at least. And I'm not aware of any state law that mentions civil rights laws or Title IX. I will say that I'm aware that the Drake Group, which has worked with Congress on its variety of bills in this area, has always tried to get a civil rights or a Title IX provision in the federal law. Obviously, nothing has been passed yet, but our hope would be that there would be some guidance there with respect to Title IX too. Any comments? Don, I saw you were about to say something, I believe. No? Okay. Well, I think what I would like to do, and the Q's and A's mentioned, there are a number of things we have talked about today that could potentially be violations of rules or laws separate from Title IX. Whether it's, the scholarship limits that the NCAA imposes, or again, what we've talked about with respect to inducements and recruiting. So it's not just a Title IX question with all these, there's an intersection amongst a number of problems with some of these NIL deals. I guess I'd love to end with just asking you, what is the big takeaway here? What do we want to say to our audience about what needs to be done, and any cautionary remarks that you want to provide?
I would start by saying I wish we had started tackling name, image, likeness when the internet was invented, created, began, and we're playing catch up, and that never feels good, and that's probably why we're in the place we are today. But ultimately, I think once we settle in and figure out the guardrails and get our arms around it, I think this is going to be a tremendous opportunity for student athletes. The headlines are grabbing some of the biggest deals, or the most egregious, or the ones that traipse, really close to the pay for play line. But by and large, I feel like we're going to have a majority of the deals, maybe not the dollars, but really being beneficial and putting some extra cash in student athletes' pockets for the right things, giving pitching lessons or writing code or starting their own businesses. And I love that idea. I just hope we can find I'm optimistic. We should do it sooner rather than later, but we need to find our way through to how to do it permissibly and give schools guidance on how to just drive on this highway.
Let me pitch in a little bit. I'm a perpetual optimist, but the thing that concerns me the most is the NIL progress was a student right to begin with that the NCAA buried in every court case, in every effort. It just wasn't on the side of students in terms of open employment rights like any other student outside of school. And so that being said, but the thing I fear the most is the loss of our responsibility as higher education institutions to treat students as students and not employees. Nobody's mentioned, and we're still looking at what the NLRB is going to do with its recent legal counsel decision in a complaint that's just been filed. We are getting closer and closer to the edge of we're not going to be able to keep that student line. If institutions get into bed with their students on outside employment and get into co-licensing and group licensing arrangements, and the students have a call on that money in some way, they're going to have a call on television media rights money too, eventually. We have crossed that line of separation when we go into business with our students.
Agree. Julie, any final comment?
I would just second what Commissioner Navarro said and Donna just referenced. I think, there's a long history, unfortunately, of undervaluing and even devaluing women's athletics. And the article, I think, by Victoria Jackson that I read last week, I cited a Deloitte analysis that in the wider 21st century in the sports industry that exists outside of American college sports identified women's sports as the greatest growth area. And for now, in the foreseeable future, and even the NCAA's own commissioned report with the Kaplan report, the phase 2 of that report, found that gender disparities in the NCAA championships stem from the structure and culture of the NCAA itself. So I think there's a lot of potential here, and if we come up to speed with the law and Title IX as we enter the 50th anniversary, that will certainly have an effect on the marketplace.
Perfect. And this clearly is a developing story. It's a work in progress. And we know there are things coming up like the House and Oliver antitrust case that may permit colleges to directly pay athletes for their NILs. We know about this NLRB opinion. Who knows what's going to happen with classifying athletes as employees? That will change the rules with respect to Title IX too. It will probably make it more clear as to what the school's Title IX obligations are, as opposed to some of these gray fuzzy areas. So I want to thank each of you. You have been incredibly insightful and thoughtful. Really appreciate your time today. And thank you to the audience. I know we didn't get to everybody's questions, and we will work to answer those after this is over. So again, stay well, stay happy, and continue to watch this space.